Hello students, once again. Now we will see registration of partnership. Registration of partnership is not compulsory under law, but as per the Partnership Act 1932, if the partners desire, they may register the firm with the registrar of firms of the state in which the business is located, in the main office of the state. A firm may get registered at the time of formation or any time afterwards. Procedure for registration. Now what is the procedure? In order to get partnership firm registered, an application in prescribed form is to be filled with the registrar of firms. The application contains name of the firm, principal place of business of firm, name of other places where firm's business is carried on, names in full and permanent address of partners, the date on which each partner joined the firm, duration of partnership if any. So the application contains name of the firm, the principal or the main place of the business firm. If there is any other place where the business is carried on, the name of that place, the full and permanent address of the partners, date at which the partners have joined, they may join together, they may join one after the other, and duration of the partnership. The partnership may be for lifelong or maybe for 15 years or maybe for 2-3 years depending on the type of partnership. Okay. So, the partnership we can enter to construct a stadium or construct a colony or building, road. So, it can depend on the years of completion. So, duration of the partnership if any. The application should be signed and verified by each partner. So, after the application is filled, it should be verified, checked by all the partners and signed and duly stamped. Then it is submitted to the registrar of the firm of the area in which the principal place of the firm's business is is situated or proposed to be situated. So, after the application is filled, it is signed and verified by each partner, then it is submitted to the registrar of the firm of the area, the principal place, and along with the application a small amount of registration fees is also deposited. Now, the application which is submitted to the registrar is examined, and if the registrar is satisfied that everything is in order and legal and there are all the legal formalities have been observed, he or she, the registrar, will make entry in the register of the firm and then will issue a certificate of registration. Now, if you want to make any changes at the time of registration, you need to communicate with the registrar, and the registrar will make the necessary changes and will give you certificate of registration. Registration does not provide a legal entity to the partnership. Legal entity means separate identity. It means that even though the partnership is registered, the partnership firm has got no separate. It is not separate. Partners, if they die, it will close down. Okay. So, the registration does not provide that it becomes a separate identity to the partnership firm. Consequences of non-registration. Now, it says that registration is not compulsory, but if you want, you may go to the registrar of the firm or the state of the main office of the state and get registered. But if you do not register, the partnership firm can suffer the following limitations. It cannot enforce its claims against the third party in the court of law. So, if there is any claim they have to get from the third party, they cannot claim it in the court because there is no name registered as partnership in the anywhere. So, there is nothing to prove. It cannot claim adjustment for the sum exceeding rupees 100. Suppose an unregistered firm owes 1200 to A and A owes 1000 to firm. The firm cannot enforce adjustment of 1000 in the court of law. Simple. the firm owes has to give 1200 to A and A has to give 1000 to firm. So, what will the firm say? Since you have to give me 1000, what we should do? I will give you only 200. No, they cannot enforce the adjustment of 1000 in the court of law because it is not registered. They have to pay that 1200 even though A has to give them 1000. It cannot file a suit against any of its partner. So, if there are partners and if one partner want to file a case against the other partner, he or she cannot file a case because it is not registered. Partners of an unregistered firm cannot file any suit to enforce the right against the firm. So, partners also they cannot file a case against the firm if they want to file against the rights, or if they are not getting any rights, if they want to file a case, no, because the firm is not registered. A partner of an unregistered firm cannot file a suit against other partner. So, these are the consequences. You cannot claim against third party, you cannot claim adjustment exceeding 100, you cannot file a suit against any of its partner, like you are the person and you got cheated by the firm. So, you want to file a case against the firm or against the partner. You cannot file a case because that is not a registered firm and the court will not listen. And even they cannot file case against the other partners. Now, non-registration of firms, however, does not affect the following rights. So, even though there is no registration of the firm, it will not affect the following rights. The right of partner to sue for dissolution of the firm or for the accounts of a dissolved firm, or to enforce any right or power to realize the property of dissolved firm. Okay. So, even though if it is not registered, it will not affect the following right. Right of a partner to sue for dissolution of firm or any right or power to realize the property of the dissolved firm. So, if one partner has got a right to get the amount from the dissolved firm, they have got the right and power to realize or get the amount from the dissolved firm. The power of an official assignee or receiver to realize the property of an insolvent partner. The rights of firm or its partners having no place of business in India. Any suit or set off in which claims does not exceed rupees 100. The right of third party to sue an unregistered firm of its partner. The right to sue a third party for infringement of a patent right. So, here even though there is non-registration of the firm, these rights will not be affected. The right of the partner to sue or to get the amount realized from the dissolution of the firm. The power of an official assignee or receiver to realize the property of the insolvent partner. Like we have ABC, A becomes insolvent. Okay. So, cannot run the business. So, B and C will have the right to receive or realize the property of the insolvent partner. The rights of the firm or its partners having no place of business in India. Okay, so here it says that it will not be affected the rights of the firms or the partners who are not having the rights of the firms or its partners who are not having place of business in India. Okay, so it will not affect So, even if they are partners from other place, it will not affect. Okay. So, if there is any claim not exceeding rupees 100, less than 100, it will not affect. They can get the right of the third party to sue against the unregistered firm, the right to sue the third party for infringement of patent right. So, here it says that you can file a case, it will not affect. You have a right as a third party to file a case against the unregistered firm. You have a right to file a case against, you as a third party can file a case against the firm, okay, and the firm can also file a case against the third party. None of your rights will be taken away from you. But if there is non-registration, in some cases the court may not listen on your favor, and then you may come into a loss. So here it says that non-registration will not affect, it will not affect any right. But if in any case the court may not listen in the favor of the person or the firm who is filing a case, so the registration somewhere should be important. So you go through the features, partnership deed, registration, procedure, consequences, and what are the various places where it does not affect the rights. And have a good day. Thank you.